Good afternoon, and thank you for joining the second in a series of Jones Day webinars on transforming the Minneapolis Police Department. Today's webinar will examine the Minneapolis contract with their police federation. My name is Andy Luger. I'm a partner in the Minneapolis office of Jones Day and the former United States Attorney for Minnesota. We are offering these webinars and these materials as part of our ongoing constitutional policing initiative. These materials in this webinar was not provided for or commissioned by any entity or client or city. They're offered for your information, and we hope you enjoy and learn from this program. Joining me today and moderating the discussion is Ronald Sharp. Ron is a partner in the DC office of Jones Day in the investigations and white-collar crime practice. Before joining Jones Day, Ron served as a United States Attorney for the District of the Virgin Islands. Ron also served on the Attorney General's Advisory Committee, where he helped the Justice Department formulate policy in response to the deaths of Eric Garner and Michael Brown. Ron?
Thank you, Andy. It's a pleasure to be part of this project. Let me introduce two of my partners. First, Trish Dunn. She's a partner in Jones Day's labor and employment practice in Washington, D.C. Trish has practiced labor law for over 35 years, with 24 of those at Jones Day. She also served for a decade as the Washington Post's Vice President of Labor. She regularly represents employers in collective bargaining negotiations, arbitrations, and labor-related litigation. I'd also like to introduce another partner, Rasha Shields. She's a partner in Jones Day's business and tort litigation practice in the Los Angeles office. Rasha has more than 15 years of trial and appellate experience. Prior to joining Jones Day, Rasha was an assistant United States attorney in the Central District of California for more than 7 years. She also served as the deputy chief of Organized Crime and Drug Enforcement Task Force. There, she supervised other prosecutors and provided routine training to federal, state, and local law enforcement. She also serves on the firm's Diversity, Inclusion, and Advancement Committee and was awarded the California Minority Council Program's Law Firm Diversity Leader Award in 2018. Rasha, can you please describe the methodology the Jones Day team used for this project?
Sure. Well, we first started with a very detailed review of the Minneapolis contract. And just to provide a little bit of context here, the contract is 95 pages without attachments and also has over 100 provisions or subparts. So based on our review, we ended up identifying about a dozen or so provisions that could potentially impact police reform efforts. So once we identified those provisions, we analyzed police union contracts from across the country. We found about 30 or so publicly available police union contracts for major US cities. And we looked at how those cities tackled these same issues. In some instances, we identified that many contracts had similar provisions to Minneapolis, and in other instances, some cities had other provisions that could potentially hinder police reform efforts in different ways. But in many instances, we were able to identify particular different approaches taken by cities that could potentially foster police reform efforts. And so we will be highlighting and discussing some of those provisions in today's webinar, and also in the accompanying handout, we identify some additional provisions and samples there. Once we looked at these provisions, we also attempted to identify the legal and negotiation considerations that would go into changing these provisions, and Trish will be discussing those in more detail. We looked at also the areas where changes can be made without a change in the law, and also those areas that would require a change in the law. Trish?
Thanks, Rasha. It's important for us to say up front what this project is not about and what we're not attempting to do in this webinar. First, we want to make clear this is a presentation that identifies areas for possible reform of the contract. It's not a judgment about the current contract. Second, we're not attempting here to set the priorities for the upcoming labor negotiations with the city and the union. Those are for the city and the police department to determine. And third, we're not evaluating here whether and how these kinds of changes that we're going to be talking about can be achieved in the labor negotiations. Rather, our goal is simply to inform, to provide people with a comparative analysis and considerations so that the city can use that as a tool as it pursues police reform.
Thank you, Trish. Rasha, I have a couple of questions for you as we get started. Can you first give us a quick overview of the topics that we're going to be covering that do not require changes to the law? As I understand the work that you and Tricia have done, there are changes to the law that are required for certain changes and provisions, but why don't we start with those that can be accomplished right now without any change in the law? Thank you.
Sure, I'd be happy to do that. And let me share with you the PowerPoint that will address some of these issues. First, we've identified about 10 or so topics where alternative approaches may be adopted without the need for any legal change. For each of these topics, we'll identify the issues that the current provisions potentially can impact police reform efforts, as well as some of the alternative approaches taken in other cities. These 10 topics include management rights, the potential to limit some of the requirements that all disciplinary proceedings be subject to binding arbitration, the use of past practices, how disciplinary investigations are conducted, the scope of the bargaining unit and whether they include supervisors, slowdowns and sick-outs and the consequences of engaging in those types of behavior, the city's discretion to handle personnel issues such as transfers, promotions, and layoffs, the retention of disciplinary files, as well as the city's ability to require psychological examinations and drug and alcohol testing. And for a couple of these instances, we've identified changes that can be made without a change in the law, but for a more drastic change to actually occur, a change in the law would be required. And for that, I'll turn that over to Trish to discuss.
So there are basically 3 provisions that would require legislative change if the city wanted to negotiate some material changes to the contract in this area. First, and quite important, is the arbitration of discipline. That is statutorily required in Minnesota. So for there to be any change in mandatory arbitration of disciplinary actions in the collective bargaining agreement, there would have to first be legislative change. The second area deals with investigation protections. Some of these investigation protections are spelled out in the Police Bill of Rights in Minnesota. So the city would need to consider whether it will need to make changes in the area of the Police Bill of Rights legislatively if it wants to increase some of the flexibility to conduct to conduct investigations in a way different than what is currently required under the collective bargaining agreement. The third area deals with indemnification of police officers. Minnesota law covers that area pretty expansively, providing for indemnification in both civil and criminal actions involving police officers. So any change in that area in the collective bargaining agreement would necessitate legislative change.
Rasha, you mentioned management rights, the management rights provision. Let's start there. What issues, if any, did you identify with that provision?
So the management rights provision in the Minneapolis contract is pretty generic. It doesn't spell out exactly which rights the city has expressly retained. And I have to admit that the first time I read the contract, I skimmed right over this provision. And it wasn't until I saw how other cities handled this issue that I really saw what the issue is. In other cities, they have very robust management rights provisions that list out almost a laundry list of all of the rights that are retained by the city and that the city does not have to bargain away. And it really is, once you identify the management rights that the city is able to retain, that means that those can be altered and changed and reformed without the need of renegotiating a union contract. And also looking at some of the contracts I saw, for example, Dallas and Denver had very short police union contracts. Most of it was focused on wages and benefits and did not go into any kinds of restrictions on the ability to handle their workforce through hiring, firing, training, etc. So they had very short police union contracts. In contrast, Minneapolis, like many other cities across the country, cover a lot more issues and provide more restrictions on the city to handle personnel issues, disciplinary issues, and the like. So these types of provisions could limit the city's ability to make reform efforts. And it can also hinder a police chief's ability to manage its own workforce if they don't retain the right to handle certain personnel issues. And so looking at an alternative approach here, Dallas has one of the most robust management rights provisions that I've seen. And it lists a laundry list of rights that are retained. I think this kind of gets the gold star standard here. It lists out 8 non-exhaustive categories, the first of which includes a long list of very important rights, such as the right to hire, train, promote, discipline, transfer, lay off employees. The Dallas contract also contains a complete agreement or a zipper clause that Trish will discuss in more detail, but also the accompanying handout, we've identified several other cities that have pretty robust management rights provisions that can be used as exemplars, including Austin, Chicago, Las Vegas, and Seattle.
Trish, can you give us a perspective from the collective bargaining approach on how important this management rights topic is?
Sure, Andy. This is a really important topic that implicates legal, contractual, and operational issues for an employer. So legally, a public employer does not have to cede any of its management rights in a labor contract, and can, like Dallas and some of the other cities that Rasha mentioned, include a non-exhaustive list of those rights in a labor contract. So for some legal context, under the Public Employment Labor Relations Act, which I'll refer to as PERLA, under this webinar, a public employer is not required to meet and negotiate on matters of quote unquote inherent managerial policy. The employer and the union only have to meet and negotiate over grievance procedures and the terms and conditions of employment under Minnesota law. Now, while that line between inherent managerial authority and terms and conditions of employment is not always clear, what is clear is the obligation and duty is to bargain in good faith, and that applies to both unions and employers. PELRA, importantly, does not require a public employer to agree to any proposal or to make any concessions. In other words, the employer is free to negotiate in good faith and reject items that it deems unacceptable to its operations. So contractually, negotiating a non-exhaustive list of management rights into the collective bargaining agreement, like Dallas has done and other cities, it could provide some important clarity for the employer, for the union, and for employees as to where these parties draw the line between managerial authority and terms and conditions of employment that they agree to restrict. It could also provide, as Rasha mentioned, a mechanism for allowing the city to exercise some management rights unilaterally without triggering disputes under the collective bargaining agreement, especially if that management rights clause is coupled with 2 other items. And I'll hit them here and we'll talk about them in a moment later. One is an exclusion of management rights in this list of items from arbitration, because that is an inherent managerial list of items. The second is a zipper or complete bargaining clause, and that's shown here on the slide relating to Dallas. And a zipper clause basically zips up the contracts, and it protects the employer's right to implement changes unilaterally during the course of the contract in areas where it needs to act, and here in areas that could be critical to police reform. So operationally, a strong management rights clause, an exclusion of those rights from arbitration, and a zipper clause could significantly increase flexibility and facilitate ongoing reform efforts during the term of the collective bargaining agreement, rather than having to deal with those every 2 to 3 years when a labor contract arises.
Rasha, following up on Trish's comments about arbitration, what did you find on that topic?
Yes, with regards to arbitration in the Minneapolis contract, first, disciplinary proceedings are subject to the grievance procedures in the contract, and that requires binding and final arbitration. And although arbitration is generally pretty common in labor contracts and can be a efficient mechanism to resolve contractual disputes, arbitration is not necessarily the ideal mechanism for dealing with disciplinary decisions for police officers. The use of final and binding arbitration has the potential of impacting police accountability. We understand that oftentimes arbitration decisions will reverse or lessen the penalties that have been prescribed by the police chief or other department leaders, and that can result in officers being put back to work that could have potentially been terminated or otherwise disciplined, and that could impact a leader's decision down the road whether to discipline an officer in the future. So binding arbitration in this context can impact the police chief's ability to manage the department effectively. And it's not necessarily ideal to have the final decision of police officer discipline be in the hands of a third party that is not reviewable or otherwise accountable to the community. And in addition to the disciplinary proceedings being subject to arbitration, in addition, the arbitrator, the provision provides a very broad definition of grievances, which can also encompass the city's management rights, which Trish is just discussing about how that should be excluded from arbitration if possible. So that is another potential area here where the Minneapolis arbitration provisions are fairly broad. Some of the alternative approaches is in Denver. The Denver provision has a very narrow definition of grievance and expressly excludes disciplinary actions from those grievance procedures. And likewise, Washington, D.C. expressly omits management rights from being subject to the grievance procedure or arbitration.
So this is another area that has important legal, contractual, and operational issues and implications. So legally, Minnesota, as Rasha said, requires the contract to provide for binding compulsory arbitration of all grievances, including grievances involving disciplinary action. But importantly, the statute does not otherwise define what those grievance procedures are, nor does it define what the scope of the arbitrator's authority should be. So that should leave some room in negotiations to bargain an arbitration provision that's more protective of management rights and its efforts at reform. So from a contract negotiation perspective, even in the absence of legislative change, the city can consider negotiating a number of changes to the scope of the grievance and arbitration process. And we'll just highlight them. Again, we're just raising information and offering things to consider. It could consider eliminating the broad grievance definition and narrowing the definition of a grievance to only violations of specific provisions of the contract, and here, when legislation so requires it, disciplinary actions, rather than any interpretation or any possible application of the contract, which is very broad. It could also consider excluding the exercise of management rights from arbitration explicitly, just like Washington, D.C. has done here in the language that's on the screen. The city could also consider excluding from arbitration any matter that's not specifically set forth in the contract. So things like past practices, which we'll talk about in a moment, so that you can't refer to things outside the contract that could be made binding through arbitration. So these kinds of changes really to the scope of the arbitration language and the grievance definition could provide the city significantly more flexibility in implementing reforms. So while the city currently has to provide for arbitration of discipline under current law, it can also consider negotiating to set some limits on the scope of arbitration in disciplinary matters, even without legislative change, so that it can maybe minimize some of the risks that Rasha identified, including the risk that an arbitrator might substitute his or her judgment for that of the city in disciplinary matters. So some examples for revision of this structure might include preventing an arbitrator from second-guessing the disciplinary decision itself, and rather letting the arbitrator simply determine the facts. Did the facts exist? And that way leave the city's determination on discipline free to stand if those facts existed. Another option might be requiring the arbitrator to defer to the department's disciplinary decisions unless it meets a high standard, unless the action's arbitrary or capricious, or somehow create a presumption in favor of the city's action in disciplinary action. A third item to consider is perhaps barring an arbitrator from sort of instinctively applying progressive discipline in police misconduct cases and preventing an arbitrator from overturning discipline on that basis, so that it doesn't have to be several instances of misconduct before a termination can occur. In fact, a termination could occur on a first instance. Other options include suspending the union contract arbitration process pending the outcome of any criminal proceedings, so that the criminal proceedings would take precedence and have a determination before any arbitration proceeding went forward. Another thought would be if there is a more limited arbitration process and a narrowed arbitrator's authority, then can you provide for an emergency or expedited appeal to a court, to a civil service commission, or to some other venue, so that an arbitrator who overturns the judgment of the city would have to have a level of review to make sure that they conformed with the heightened standards that were negotiated into the contract. So operationally, putting limits on the scope of arbitration and the arbitrator's authority might be ways to address, even without legislative change, the problems that arbitration can pose to reform efforts and discipline efforts in the police department.
Thanks, Trish. Rasha, can you talk about some other areas that you examined that can impact the city's management rights and be a potential barrier to reform?
Sure, Andy. One interesting provision that's in the Minneapolis contract is this past practices provision, which provides certain circumstances in which past practices and custom can be used as evidence for certain situations. This provision's interesting because it's unique to Minneapolis. And all the other contracts that we reviewed, we didn't find anything similar to this. The issue here is giving contractual effect to vague, unwritten, and undefined rules, and that can pose an obstacle to certain reform. For example, the union or employees could potentially use past practices as a defense to certain reforms, saying that the reform efforts are inconsistent with past practices or custom. Or similarly, the union can use past practices and custom as a way of trying to limit the city's ability to exercise their inherent management rights, saying that that wasn't done in the past. And so these types of provisions could potentially impact reform efforts. In contrast, I wanted to highlight a provision that Memphis has, and here the Memphis actually prohibits the use of past practices or unwritten custom to the extent that's being used to try to limit the city's inherent management rights or to claim that the city has condoned or tolerated a certain practice in the past.
Past practices do have a role in labor management relations, and arbitrators regularly look at past practices in interpreting a labor contract, and that's the point made in paragraph B of the Minneapolis labor contract. But that's a very different proposition than giving contractual effect to unwritten, undocumented practice that doesn't have any footing in the labor contract. So the items in A and C and the Minneapolis contract. That kind of thing, as Rasha mentioned, can pave the way for challenges to management rights based on unwritten, outdated, and potentially ambiguous practices that the parties don't mutually agree about. So this Minnesota provision that Rasha talked about is solely a creature of contract. We found no Minnesota law or Minneapolis ordinance requiring a collective bargaining agreement to in any way address or define past practices or give them any evidentiary value. So the city can certainly consider a different approach in bargaining that minimizes the role of past practices. So it could consider bargaining to eliminate that past practices provision altogether. It could also consider doing something like Memphis and looking at this language on the screen to provide that past practices can't serve as a limitation on management rights or in any way used as evidence that the city tolerated a certain practice. So the goal would be to codify in the four corners of the document, of the contract document, any practice that the parties deliberately talk about and mutually want to agree in a labor contract and make binding, but not include in any of these unwritten practices that could stand in the way of reform.
Thank you, Trish. Rasha, let's turn to an important management right, the right to investigate police complaints or incidents involving the use of deadly force. I'm sure you looked at that. What did you find?
Yes, the Minneapolis contract does contain certain restrictions on the manner in which investigations can be conducted. First, before an officer can be interviewed, the city's required to give the officer a written, detailed statement summarizing the events and describing the alleged acts or omissions that are at issue, as well as the policies, rules, and regulations that were allegedly violated. Second, the officer ordinarily has 2 days to review the summary before being subjected to an interview. And third, the officer is entitled to have a union representative or a lawyer present during the questioning. And although the first two conditions can be exercised or excused, under certain circumstances, the city is still required to involve the union in those decisions and process. In addition, with respect to critical incident investigations, and critical incidences are defined as incidences involving the use of deadly force by or against a police officer, or when a person in the custody and control of an officer dies or sustains substantial bodily harm. In those investigations, there are additional limitations here as set forth in section 26.05. Other than the certain exceptions listed here, an officer who either witnessed or was involved in a critical incident is not permitted to give a voluntary statement and can't be asked to give a voluntary statement before the officer has consulted with legal counsel. So all of these conditions can impact the accuracy and efficacy of a fact-finding investigation. They eliminate the element of surprise, and instead of getting a candid and unprepared statement, the 2-day cooling off period or the consultation with legal counsel before providing a statement can provide, ample time for someone to get the story straight or change the facts to comport with the summary that's being provided, so that the interview itself may not be as fruitful as what would have occurred without these conditions. And just as law enforcement officers who are investigating crimes likely wouldn't want to be subject to these types of conditions, the city should also consider whether these types of conditions are impeding their own ability to conduct their investigations. Now, in terms of how other cities handled this issue, several cities do not include any limits on investigations in their police union contracts. These cities include Dallas, Denver, Boston, and Las Vegas. And again, going back to Dallas's broad management rights provision, it's a great example of expressly providing that the city retains the inherent management right of investigating officers and complaints relating to officer conduct. But again, it's also worth mentioning that many other cities have similar conditions that Minneapolis has, and some have even more conditions, such as requiring the police officer to have access to video witness statements and other investigative materials before being interviewed. So Minneapolis is definitely on a spectrum here, but the Dallas is a good example of ones that reserve the right to conduct their investigations in the way that they find most effective.
So this is one of those areas where the Minneapolis contract goes well beyond what Minnesota law would require in connection with ensuring that police officers are accorded appropriate process in investigations. So legally, the structure in Minnesota is the Police Bill of Rights, which we touched on a bit earlier, and it imposes some conditions on when and how a police officer's formal statement may be taken. So, for example, it provides that an officer's formal statement may not be taken unless there is filed with the employer investigating agency a written complaint signed by the complainant stating the complainant's knowledge, and the officer has been given a summary of the allegations. That's one requirement. The Bill of Rights also provides that the officer has the right to have a union representative or a lawyer or both present at the session where he or she gives a statement. The bill also limits these interviews to a reasonable amount of time, gives officers breaks that are not usually given to civilians, and limits interrogations to time when the police officer is on paid work duty. So those are sort of that's a framework of the Bill of Rights to provide certain protections to police officers. But the Bill of Rights does not expressly require an officer to have, for example, a certain amount of time to review the allegations or review a summary before a statement is taken. That's a creature of the collective bargaining agreement, the two-day cooling off period that Rasha mentioned. So the city could certainly consider negotiating contract terms that meet the minimum standards of the Bill of Rights, but otherwise retain the city's management rights to conduct unencumbered investigations that might lead to discipline against a police officer, like Denver and some other cities do. So just for example, again, as some thoughts to consider, the city could consider negotiating to add, like the Dallas contract does here on the screen, the right to conduct pre-disciplinary investigations to the management rights clause, to list it as one of those items that the city has the unencumbered right to do. The city could also consider removing that two-day cooling off period, other restrictions on providing statements, and other non-statutorily required restrictions on investigations. The city could also certainly revisit the whole framework it has for dealing with critical incidents, and as well as the arbitration process that gets triggered in that process after a certain number of days. All of those are creatures of contract as well. So these changes or potential changes could allow the city to look at pre-discipline matters and handle pre-disciplinary investigations as a matter of internal departmental policy, like some other cities do. And putting that kind of pre-discipline investigation squarely in management's discretion and control could allow the city to do a fair and full investigation without getting tangled up in certain processes that go beyond what's necessary to afford the officer appropriate process. The CBA could still, the contract could still allow both the union or an employee to challenge the decision imposed in terms of discipline through whatever process they negotiate into the contract or through arbitration as is statutorily required.
Rasha, one of the things that I know you looked at is the role of supervisors in exercising disciplinary actions and management decisions. Can you talk a little bit about what you found in the contract with respect to that?
Sure. The Minneapolis contract covers both police officers as well as their supervisors, sergeants, and lieutenants in the same bargaining unit, subject to the same rules and restrictions that we've been discussing here. As Trish will explain, this leads to potential issues under Minnesota labor law. And when supervisors are in the same union group as the officers that they supervise, it raises potential concerns about diminished supervisory oversight and accountability. And it also creates the potential for conflicts of interest with the city's own needs, especially as to discipline and other personnel management issues. In terms of how other cities do it, several cities exclude supervisors altogether from bargaining units, such as Chicago, Phoenix, and Washington, D.C. Some cities like Memphis and Seattle, it limits leadership only to the sergeants, so they don't include the lieutenants. And some cities, not pictured here, but included in the handout, have separate bargaining agreements with supervisors, such as Boston, Costa Mesa, and New York. So for example, Boston has separate bargaining agreements for patrolmen, for superior officers, and also for detectives.
So the Minnesota contract, based on what Rasha just teed up, presents some pretty interesting legal and bargaining issues. The legal considerations stem from the fact that, as Rasha noted, the collective bargaining agreement covers supervisors, including lieutenants and sergeants, in the same bargaining unit with police officers, in the same unit with the people they supervise. Importantly, the city and the union have agreed, and they state in writing in the contract, that lieutenants and sergeants are statutory supervisors under Minnesota law. So while we're not privy to the history of that arrangement, the collective bargaining agreement's explicit reference to the Minnesota statute defining these folks as supervisors basically acknowledge that the positions exercise the majority of the 10 functions that lead to a determination of supervisory status. So the ability to hire, transfer, suspend, promote, discharge, assign work, reward, discipline, direct work, or just grievances, all those indicia of supervisory status. So the arrangement in Minneapolis presents some interesting legal issues to consider, because Minnesota law appears to preclude including supervisors in the same bargaining unit with non-supervisors. Minnesota law also provides that an employer can seek to remove supervisors from a unit that includes non-supervisors, either with the union's agreement by bargaining or by getting a determination from the commissioner of the Bureau of Mediation Services. So this doesn't mean that supervisors can't be union covered. It's just that they should be in their own unit of other supervisors and not in a unit that includes both supervisors and non-supervisors. In fact, the statute's clear that supervisory employees can form their own labor organization, and that the employer would have to bargain with such a union representing the supervisors. So this legislative landscape raises some interesting bargaining issues that the city might want to consider. And stemming largely from the fact that the current collective bargaining agreement basically acknowledges that the sergeants and the lieutenants are in fact statutory supervisors, the city could consider negotiating with the union to remove these supervisors from the same bargaining unit with the police officers on the basis that they shouldn't be in the same unit with the employees that they supervise. If that outcome, for whatever reason, can't be reached by agreement with the union, the city could explore possible legal avenues for redefining the scope of this unit to exclude supervisory positions from the bargaining unit, including possibly securing a determination from the Commissioner of the Bureau of Mediation Services on that point. Supervisors could conceivably be exempted altogether from union coverage, or another possibility is bargaining a separate agreement that would cover only the supervisors and that would include terms that are appropriate for supervisors. In any event, looking at the Minneapolis collective bargaining agreement, there are certain terms that apply both to supervisors and non-supervisors that the city might want to explore addressing so that it has more flexibility in scheduling, assigning, giving direct reports to the police officers. In other words, putting them where they need the supervisors at all times. So that's the landscape in terms of supervisors, and it's an important one that raises a lot of issues worth analyzing in connection with the bargaining and the legal framework.
Trish, thank you for that explanation. I'm going to turn to you, Rasha. It's been reported that the reform of police policies has sometimes led to some officers engaging in slowdowns and sick-outs. How does the Minnesota contract address those issues?
Yeah, it's a very valid concern. The Minneapolis contract does have a no strike provision, which prohibits strikes, slowdowns, and other similar conduct. It does not specifically mention sick-outs, which can significantly impact police operations. Some contracts in other cities list out sick-outs as a specific prohibited conduct, but that would likely fall within the catch-all phrase in the Minneapolis contract of, quote, willful absence from one's position, which presumably a sick-out is. But focusing on the consequences to an employee who engages in these prohibited conduct, the provision provides that an employee, quote, may be subject to disciplinary action. And it's that language that we want to focus on a little bit here. You know, given the importance of police services and the city's dependence on them, the city can consider adding more significant consequences for employees who engage in, you know, strikes, sick-outs, or slowdowns, rather than just the threat of potential disciplinary action. In some of the other cities that we saw, the other approaches, Memphis and Dallas had some of the strongest consequences here for employees that engaged in this type of prohibited conduct. And I imagine these types of provisions go a very long way in deterring this type of behavior. In particular, in Memphis, the striking employee would be subject to, quote, immediate and permanent dismissal, together with the loss of all employee benefits, including but not limited to pension benefits. Likewise, in Dallas, a striking employee, quote, forfeits all civil service rights, reemployment rights, and any other rights, benefits, or privileges that the officer enjoyed as a result of his employment or prior employment. So these are pretty significant consequences here that are spelled out and more likely to result in deterring this type of behavior.
Existing law is very clear on this. Police officers do not have the right to engage in strike, unlike private sector employees. Minnesota police officers are under law essential employees, and the city is entitled to have their uninterrupted services without strikes. So Minnesota law does provide an avenue for addressing illegal strikes. Minnesota law makes it an unfair labor practice for a public employee or union to refuse to perform services. That process allows the city to seek redress for illegal strikes of the Public Employment Relations Board through a relatively new process, which handles unfair labor practice charges dealing with matters like this. But significantly, and this goes to the point that Rasha was referencing in terms of the consequence to the police officer, The legal recourse through the state may or may not be effective and certainly may not be timely, especially where there is a one-day sick out or a one-day strike in violation of both the law and a no-strike clause. So because statutory recourse may not be effective or timely in the instance of a one-day strike or a sick out, the city may want to consider bargaining some changes to its current no-strike clause to include some of the more stringent enforcement mechanisms that might deter an illegal strike, as Rasha was talking about. So a couple of things to consider. So for absolute clarity, the city may want to consider adding sick outs to the list of items that would constitute an illegal strike under the contract. It also might want to consider making automatic dismissal of employees the consequence for a violation of the no-strike clause, as some of these other cities have done. Could also consider, like the examples on the screen, loss of certain benefits in connection with violation of a no-strike clause. Again, the cities are entitled to the services, the important services of the police to provide safety and security to the community. And these strikes can be very detrimental to that purpose. So these sorts of consequences would provide a stronger deterrent than the current language, which says police officers may be subject to disciplinary action, and they're worthy of consideration. One thing of note here, I mean, since pensions are not really a matter of negotiation under Minnesota law, whether a loss of pension benefits could be included as a penalty for an illegal strike is something that's beyond the scope of this webinar, but it's worth mentioning that that kind of consequence certainly is available in other areas in other cities.
Rasha, can you talk a little bit about the Minneapolis contract and how it impacts on the police chief's ability to make personnel decisions compared with other cities?
Sure. The Minneapolis contract does place certain limits on the city's ability to make certain personnel decisions, including decisions relating to transfers and promotions. The contract also applies seniority to determine certain things like bid selection, layoffs, bumping, and recalls. These types of restrictions have the potential of adversely affecting the retention and promotion of diverse candidates who are more reflective of the community. And seniority-based provisions tend to reward time on the job rather than an officer's skills and performance. So looking at how other cities handle this, some cities do not include any of these types of personnel management provisions at all in their police union contracts. Again, looking at Dallas's management rights provision, important personnel decisions like hiring, assignments, and promotions are expressly reserved management rights of the city. Other examples, San Diego, the police chief has complete discretion to select promotional candidates from a certified list of qualified candidates. In Los Angeles, the police chief has complete discretion to transfer and assign captains and hire leadership. And such decisions are not grievable or subject to arbitration. So looking at some of the examples of other cities where they're not bound by certain provisions in the contract gives a police chief more flexibility to manage the department.
This is one of those areas where the line between inherent managerial authority and terms and conditions of employment is somewhat blurred, as you can see from how Minneapolis and a variety of other cities handle these issues. It's also a topic that implicates a bedrock principle in many labor contracts, and that's the concept of seniority, that basically values time in the position over performance, skills, even diversity. And across the country in both the public sector and the private sector, that seniority concept, often a last in, first out policy, is colliding with employer effort to increase the number of women and diverse candidates in their ranks. In general, just to provide some of the legal background here, the Civil Service Commission rules tend to protect seniority and govern a number of these areas that we're talking about in terms of personnel management. Civil service rules apply to hiring, evaluation, promotion, transfer, discipline, layoff, all of those matters, and typically favor seniority rules. So for example, Civil Service Commission Rule 12 outlines the layoff procedures, which are generally conducted on the basis of seniority and classification. That again means last in, first out, which could adversely affect the retention of women and minorities on police forces. Importantly, these civil service rules can be superseded by negotiations and the terms of a labor contract. Civil Service Commission Rule 1.03 provides that agreements reached under through negotiations with the city can supersede those rules where those concepts overlap. So given that, the city may want to consider some changes in these areas of personnel management. If possible, one would be to take the approach that Dallas takes and list that all of these basic rights to hire, promote, assign, discretion, and are not matters that are subject to control through seniority rules or a union contract. If not achievable or not the priority for the city, another approach might be to remove some of the seniority rules in certain areas that can impede diversity and impact operational needs, including around the area of layoffs, bumping rights, and recall rules that tends to put the most recently hired employees at risk. Another thought and another consideration to look at would be including greater work assignment and scheduling flexibility in the contract that's not seniority dependent, not so rigidly tied to a bidding process for getting schedules, but is rather based on operational needs, community needs, and officer performance, so that officers are in the right place in the community in the best interest of the city's services. Those are just some thoughts. I'm sure there are many others in this wide area of performance management.
Thank you for that, Trish. Rasha, staying on the topic of personnel, can you speak to the retention of disciplinary files and provisions covering that issue?
Yes, this is definitely an important area, and the contract here does limit the city's ability to retain complaints and investigations in an officer's file that do not result in any disciplinary action. So if there's no imposition of discipline, then those items cannot stay in the officer's file. This restriction can hamper the city's ability to identify patterns of potential bias or police abuse. In certain instances, many complaints will go unsubstantiated because of a lack of witnesses. And just because it doesn't result in discipline, that doesn't mean that it can't inform the city's decisions down the road, whether that's relating to discipline or personnel decisions. And that may it might actually hinder the city's ability to defend their decisions in arbitration. And so just because the decisions or the investigations didn't result in discipline, that doesn't mean that these complaints can't inform the city's ability to make personnel decisions down the road, such as who to promote, who to make as a training officer, and other types of decisions here. In terms of how other cities do it, there are several cities with similar or even more extensive restrictions on the retention of certain information in personnel files, but several cities do not impose any types of limitations on the retention of disciplinary files, and those are listed here: Dallas, Denver, San Jose, and Fort Worth. And so there are no restrictions in those contracts discussing and limiting a city's ability to retain and use information that are investigations that didn't result in discipline.
Needless to say, retention of disciplinary files is a pretty common subject of labor negotiations, with the interest of the employer in retaining all records. and the interest of employees in cleaning their slates regularly colliding. We found no requirements in Minneapolis to exclude investigatory records from personnel files if they don't result in discipline. And we found no legal requirements about removing disciplinary records after a certain period of time. So that leaves the subject well open to negotiations. It's worth noting that the Minnesota Government Data Practices Act, while not directly on point, could provide some indirect support for reforming these current contract provisions. That act states that all complaints against an officer are public, regardless of whether the complaint or charge resulted in disciplinary action. The act also states that the final disposition of any disciplinary action is public. That does not include disciplinary actions if an arbitrator sustains a matter of a grievance and reverses the disciplinary action. But you can tell from the statute there is a public interest in information being available. So given that public interest, the city may want to consider negotiating removal of the current provision in the contract prohibiting including complaint information in the file. As Rasha pointed out, that information is important to assessing patterns. It's also important to informing discipline, and it's also important to informing personnel decisions. In addition, the city may want to be explicit in the contract and negotiate language that makes clear that disciplinary records remain permanently in personnel files so that they can be used for the purposes that we just discussed.
Rasha, can you talk about how the contract addresses issues of fitness and psychological testing?
Yes, the contract provides 5 specific instances in which the department can require an employee to submit to psychological evaluation, including defining when reasonable cause exists to believe that an employee may not be fit to perform their essential functions. And in cases involving the critical incidents, psychological debriefing is required for officers involved in the incident, but not those who witnessed the incident. That's just they can go to psychological debriefing, but it's not required. Some of the alternatives in many of the police contracts that we reviewed, they didn't discuss psychological evaluations at all. So there were no restrictions on when psychological evaluations could occur, at least as part of the police union contract. And those cities included, Austin, Boston, Columbus, Dallas, Denver, Las Vegas, Los Angeles, Memphis, Phoenix, Seattle, and Washington, D.C. For some of the other cities that did discuss psychological evaluations, like Jacksonville and San Antonio on the screen here, they provide a lot more discretion to the police chief to require psychological evaluations at any time. So there, the police chief has much more control and doesn't have to fit the decision in one of 5 categories and has more flexibility there.
So this is an issue, this important area of fitness of officers for duty that would certainly require an assessment of the city's experience in this area and whether this contract language with the 5 items that Rasha pointed out has operated as a unworkable barrier or restriction on the city's right to ensure that the police officers it employs are fit for the duties they're asked to perform. So, but legally, it appears that the city can more broadly negotiate language that would give it more flexibility to require psychological testing of current employees. It would be consistent with the Americans with Disabilities Act, which allows medical examinations of employees, including psych examinations that are job-related and consistent with business necessity. A medical examination meets those requirements when an employer has a reasonable belief based on objective evidence that 1, an employee's ability to perform essential job functions will be impaired by a medical condition, or 2, an employee will pose a direct threat due to a medical condition. In addition, EEOC guidance states that it is permissible to conduct periodic medical examinations of employees in positions affecting public safety, such as police officers, that are narrowly tailored to address specific job-related concerns. So given the job-related fitness concerns of police officers and given their important public trust, ensuring psychological fitness is an important issue to consider. So if the city has been hampered in testing under the current collective bargaining agreement language, it is an area that it should consider negotiating a more unrestricted management right to require such testing really at any time in its discretion, like Jacksonville and San Antonio here on the screen.
Rasha, since we're talking about testing, can you tell us what the Minnesota contract speaks to when it addresses the limits of drug testing or alcohol testing of the officers?
Yes, the Minneapolis contract parallels the requirements and limitations of Minnesota's extensive laws in this area on many levels. It allows for reasonable suspicion testing, including when an employee has caused physical injury, is involved in an accident, or discharges a firearm other than in limited authorized circumstances. However, here in Minneapolis's contract, it permits unannounced testing only in connection with these last chance agreements, meaning the officer has already had one strike against them and they enter into this agreement as a second chance. And that's the only time they allow unannounced testing. It does not allow for any type of random drug and alcohol testing, which Trish will explain is authorized under the current law. And it also doesn't provide for testing as part of a routine physical examination, as some cities require. So in terms of how other cities do things a little differently, Jacksonville, Las Vegas, Los Angeles, and San Antonio all have enacted random drug testing for its police force. Jacksonville in particular has great leeway as to when the police chief can require drug testing, including in connection with routine fitness for duty exams. And some cities like Las Vegas and Los Angeles include provisions that incentivize officers to voluntarily apprise their departments of any drug problems or addictions caused by alcohol, gambling, or prescription over-the-counter medications. And so those are all provisions that may be worth looking at to incentivize officers to seek help when needed.
So Rush is correct that Minnesota has pretty extensive requirements in the area of drug testing, and obviously the collective bargaining agreements requirements in drug testing would need to comply with those statutory provisions. That said, the collective bargaining agreement here provides more protection to officers than the statute requires. So the city may want to consider negotiating to require some of the things that the statute actually allows in the area of drug and alcohol testing. And that would include, for example, random drug and alcohol testing, given the safety sensitive nature of police jobs. It may also include testing as part of routine physical exam or fitness for duty testing. That's another area that the statute allows for there to be testing of officers beyond the circumstances spelled out in the collective bargaining agreement. So again, depending on the city's experience, the city may want to consider negotiating some changes to make the testing policy more expansive and cover random testing. And it may want to consider revising the collective bargaining agreement to make the policy potentially more deterrent of drug and alcohol use if it's been an issue. So options for doing that would be providing, for example, for automatic termination for a second positive drug or alcohol test, or for a first test if the employee refuses to participate or unsuccessfully completes drug or alcohol counseling. That is permissible under Minnesota law. That is an area that the city could make a move in the collective bargaining agreement toward more potential more deterrence of drug and alcohol on the job. The city could also consider negotiating language around the arbitrator's authority in connection with any arbitration challenging a termination over a drug or alcohol test, and say, for example, that the arbitrator could only ensure that procedural testing compliance issues were met, as opposed to the level of the discipline involved. Another option might be, and worth considering, is dealing with a refusal to take a test. That is permissible under the contract to refuse to take a test. The consequences may include discipline under the collective bargaining agreement, and that may be an area that the city wants to consider a more stringent or more deterrent level of discipline for refusing to take a test absent some extenuating circumstances.
Trish, why don't we change subjects a little bit? Up till now on this webinar, we've been focusing on potential changes to the contract, the union contract, that do not require any change in state law. But there are some things that you all have identified, changes to the contract that would also require changes to state law, starting with discipline and arbitration. Can you address that issue?
Sure, Andy. This is a really very important provision that would require significant legislative change in Minnesota. Currently, Minnesota law provides that all collective bargaining agreements must include a grievance procedure, providing for compulsory binding arbitration of grievances, including all written disciplinary actions. And that process gets triggered once an employee passes their probationary period. After that, any discipline is subject to a grievance procedure and compulsory binding arbitration. So that means, and we touched on this earlier, that all of the chief's disciplinary decisions are subject to arbitration, even in cases where there has been a police conduct review panel doing the investigation and making recommendations based on that investigation of a complaint against a police officer. So that process triggers any number of the issues that Rasha talked about as to why arbitration may not be the optimal and certainly not the best avenue for dealing with discipline of police officers. This language on compulsory binding arbitration pretty much leaves to the arbitrator the unfettered discretion to make a decision on whether there was just cause for the disciplinary action. And their actions are, under labor law, largely unreviewable. Only very high standards can in labor arbitrator be overturned in connection with making decisions on disciplinary actions and substituting their judgment on disciplinary actions, which we've read a lot about as being an issue across police forces. So that kind of ability to overturn the judgment of a police chief and the police chief's ability to manage discipline within the department creates a problem that is worth considering both in negotiations, but only when and if there is a change in legislation that would allow a different process for dealing with police discipline other than arbitration. So, in short, there need to be legislative change that excluded or allowed parties to exclude from arbitration all disciplinary actions. So changing the language of the current statute. And then replacing arbitration with some other mechanism, if that was a legislative judgment, for dealing with disciplinary actions outside the context of binding arbitration.
Rasha, from your review of the contracts of other cities, how do some of these other cities review disciplinary decisions if they are not using mandatory arbitration?
That's a great question. Well, first, it is important to note that there are several other cities that use binding arbitration, similar to Minneapolis, to resolve disciplinary issues. But many other cities, including the cities listed here, Columbus, Memphis, Philadelphia, Phoenix, and San Diego, have crafted disciplinary procedures that do not involve arbitration. They opt instead to have the ultimate decision being made by either civilian boards or public officials that can be held accountable by the community. So, for example, Columbus, the final decision is made by the police chief, and that obviously gives the police chief a lot of ability to control the workforce. In Memphis, the decision is made after an administrative hearing, which by law can be appealed to the Civil Service Commission Board. And again, Philadelphia, Phoenix, and San Diego have all taken other approaches. So if there is a change in the law, this area is really ripe for additional analysis and review to really determine what option is the most effective, balancing the due process rights of officers with the need to have police accountability and transparency. But there's a lot of different options to choose from, and we've tried to highlight some here and also in the accompanying handout.
Trish, talk a little bit more, as you touched on earlier, about the state law limitations on investigation proceedings.
Sure, Andy. So as we talked about a couple of times in this webinar, the legislative framework in Minnesota turns around a police bill of rights that imposes conditions on when and where and how a police officer's formal statement may be taken. And obviously there's an important need to balance the due process interest of police officers with the need to conduct a thorough, fair investigation that leads to appropriate action on the city's part. So this police bill of rights includes a number of conditions that I touched on before, so I won't speak too extensively about them, but it does prohibit investigation of anonymous complaints. So as you can see here, it states that you have to have a written complaint signed by the complainant stating the complainant's knowledge. So that may, in fact, impede reform in police departments because some citizens or even co-workers might want to remain anonymous about a complaint about a police officer out of fear of possible retaliation. So that's one area that is worth considering, but cannot be changed in a labor contract given the current state of the Bill of Rights. The other area to look at is the point that we touched on earlier about the officer's entitlement to a summary of the allegations before giving a formal statement. For the reasons we've talked about before, that requirement in the Bill of Rights could impact the accuracy and efficacy of an investigation, and that needs to be considered as well. So evaluating whether, and if so, how the Bill of Rights should be modified in any way really requires, potentially rebalancing the city's needs to investigate promptly and fully and fairly with the employee's genuine interest in a right to a fair process. But this is a legal landscape today, and to the extent the city determines that it needs different arrangements, including potentially the ability to investigate anonymous complaints, that would in fact require legislative change.
Thanks, Trish. Rasha, the indemnification of officers is often an issue that comes up when people discuss police reform. Can you walk us through the legal framework involved here?
Yes, and I have to say that indemnification of police officers is a complicated issue, and it can use its own webinar and take up as much time as you give it here. Like many states, Minnesota has statutory provisions that require the city to defend and indemnify its officers for damages. And in Minnesota, that also includes claims for punitive damages. And indemnification occurs so long as the officer was acting in the performance of the duties of the position and also was not guilty of malfeasance, willful neglect of duty, or bad faith. Minnesota law also requires the city to furnish legal counsel or otherwise pay for legal counsel under certain circumstances for criminal matters, civil actions, and investigations of civilian complaints. So any provisions in the Minnesota contract that discusses indemnification or the payment of legal fees is not likely to change absent a change in the law. And these types of indemnification provisions usually get criticized because they often result in the city's or more likely taxpayers paying for police misconduct rather than holding the culpable officers financially liable. One study conducted by a UCLA law professor found that more than 99% of all civil judgments against police officers were subject to indemnification and not paid directly by the officers. Obviously, to the extent civil litigation is supposed to act as a deterrent to prevent police misconduct, indemnification provisions greatly undercut this purpose. But again, the issue of indemnification is complicated, and it's not so simple as to say, well, cities should just stop indemnifying officers altogether. In fact, many community activists recognize that that's not the answer, because that can result in actually fewer civil rights actions being filed. If police are personally liable without any indemnification from the city, then many of them will be judgment proof. And that in and of itself may prevent civil rights lawyers from filing lawsuits in the first instance if they have no chance of recovering any damages. So cities across the country are struggling with this issue and the related issue of qualified immunity. One idea that is getting some traction is requiring police officers to obtain professional liability insurance. The city would pay the premiums, but like car insurance, if you get into too many accidents or rack up too many tickets, your premiums go up. And those higher premiums would be paid directly by the officer and not by the city. So that could serve as a better deterrent than the current system. But of course, and unfortunately, that idea is not new to Minneapolis. In 2016, a citizen group proposed a city charter amendment that would have required police to maintain professional liability insurance. The city was not able to put that on the ballot because it actually conflicted with existing state law. And it went all the way to the Minnesota Supreme Court, and the Supreme Court agreed that it violated state law. So this is an area that is ripe for additional analysis and a review of existing law to determine how best to hold police financially accountable for their own misconduct, and whether a change of the law is required here.
Rasha, as we come to the end of this webinar and the extensive research that you and Trish and others have done to put together these slides and comments, can you just talk about other cities and unique provisions that Minneapolis may want to require or consider in future negotiations?
Sure. In looking at some of the other contracts, we identified a handful of other provisions that other contracts had that were interesting and could potentially help with reform efforts. The zero tolerance for dishonesty provision, Seattle had a specific presumption of termination for any officers where a disciplinary complaint was sustained involving dishonesty. And that's a very important provision that can combat any type of police culture or codes of silence that can impede community policing efforts. So we thought that that was a very interesting provision that Seattle includes in its police union contract, that the presumption of termination if a police officer is found to have been dishonest. And that can be based on any type of complaint, but dishonesty is the key there. In terms of community policing, some cities like San Jose and Boston had specific provisions discussing community policing. For example, San Jose had a provision that discusses attending community meetings and acting as a liaison with community action teams. Boston has a safe streets teams provision that discusses aspects of community policing, including the focus of interacting with residents and business owners, primarily utilizing foot patrols and bicycle patrols. Austin had a civilian oversight provision. It was just very exhaustive, and it primarily focused on adding additional transparency and review of complaints against police officers. A few different cities had bilingual pay incentives. That's Memphis, Phoenix, and San Diego. Included incentives for bilingual speakers, and of course, having more officers that speak the language of the communities that they are serving tends to foster better relationships in those communities and also can assist in de-escalating certain circumstances. So we thought that was an interesting incentive there. And finally, Memphis has a residency requirement. Basically, all police officers need to reside in the city of Memphis, and some community activists believe that requiring police officers to reside in the cities that they police actually leads to better police community relationships. In Minnesota, the law actually prohibits residency requirements. You can't require city employees to reside in a certain city or county. However, very, very recently, Minnesota passed a law that allows the city to provide and offer incentives to encourage police officers to reside in a particular city or county. And so all of these provisions and other types of provisions that we found are included in the accompanying handout, but we thought these were interesting provisions that were unique and not included in the current Minneapolis contract that the city may want to consider and review.
Thank you, Rasha. Thank you, Trish. We've come to the end of our webinar. I want to thank both Rasha and Trish and Ron for their hard work on this presentation. I want to make note of the email address on the screen. That is our email address for our Constitutional Policing and Reform Initiative nationwide. If you've got questions, comments, thoughts about what we should be talking about, we're interested. We hope to have another webinar ready soon on the question that is on a lot of people's minds about the difference between reform or transformation of a police department and defunding or dismantling. These things tend to take on a lot of issues and a lot of descriptions. So we're going to be doing a webinar on that topic with some lawyers and some experts. We hope you'll join us, and thank you so much for participating here today.